Good evening. 1 minute ago, the Supreme Court rejected an appeal. Not just any appeal. An appeal that could have rewritten the legal boundaries around a former First Lady, around executive privilege, and around what happens when the instruments of government are used not for the public, but for something else entirely. And Melania Trump's response? It's not what anyone expected. Let's be very clear about what just happened. This is not about partisan noise. This is about a legal mechanism that was tested, pushed to its limits, and then decisively shut down by the highest court in the land. The implications of that rejection are only now beginning to surface. And what Melania Trump is reportedly planning next has left even seasoned legal analysts scrambling to understand the strategy. Because here's the thing. When the Supreme Court declines to hear a case, it's not always because the case lacks merit. Sometimes it's because the lower court ruling was so clear, so legally sound, that there's nothing left to argue. And sometimes it's because the court knows that touching the case would open doors that nobody, not even the justices themselves, wants to walk through. So what was this appeal really about? At its core, this case revolves around a subpoena. A subpoena issued not in a criminal matter, but in a civil investigation. The details are intricate, but the principle is simple. Investigators wanted documents. Documents that allegedly involve financial arrangements, foreign transactions, and the use of certain nonprofit structures during and after the Trump administration. Melania Trump's legal team argued that, as a former First Lady, she was shielded by a form of executive privilege. Not her husband's privilege, her own. That argument was novel, it was aggressive, and it was rejected at every level. First, a district court said no. Then, an appellate court said no. And now, the Supreme Court has said, we're not even going to consider it. That's 3 strikes. But here's where it gets interesting. Melania Trump is not retreating. She's not going quiet. According to sources close to her legal team, she is preparing what some are calling a strategic pivot. Not another appeal, not a public statement of defiance, something different, something that could shift the entire framing of this case from a legal defense into a political and public relations maneuver with consequences far beyond this one investigation. Let's take a step back. Why does this matter? Because the rejection of this appeal does more than just keep a subpoena alive. It establishes a precedent. It says that proximity to executive power does not in itself grant you immunity from legal scrutiny. It says that being married to a president or having lived in the White House does not make you untouchable. And it says that when courts demand documents, creative legal theories about privilege are not going to save you. This is significant, not because of Melania Trump specifically, but because of what it means for anyone who has ever orbited the presidency. Advisors, family members, appointees. The court just narrowed the circle of who gets to claim executive protection. And they did it without even hearing the case. Now, let's talk about what comes next. The subpoena is now enforceable. That means investigators can move forward. They can request the documents. They can compel testimony if necessary. And if there's resistance, they can go back to court with the full weight of Supreme Court denial behind them. But here's the twist. Melania Trump's legal team is reportedly not planning to comply quietly. Instead, sources say they are preparing to argue that the subpoena itself was issued in bad faith, that it was politically motivated, that it was designed not to uncover wrongdoing, but to harass and embarrass. This is a different kind of fight. It's not about privilege anymore. It's about process. It's about motive. And it's a fight that doesn't require Supreme Court approval to wage. It happens in public. It happens in the media, and it happens in the court of public opinion. And that's where things get complicated. Because if Melania Trump can successfully frame this as political persecution, if she can convince enough people that this investigation is not about the law, but about revenge or partisanship, then she doesn't need to win in court. She just needs to win the narrative. And she's not without tools. She has access to some of the most sophisticated legal and communication strategists in the country. She has a public profile that, while quieter than her husband's, still commands attention. And she has a potential audience of millions who are already primed to see any legal action against the Trump family as inherently suspect. So the question is not just whether she complies with the subpoena. The question is how she uses this moment. Let's consider the legal landscape. The Supreme Court's decision not to hear this case is final. There is no appeal beyond the Supreme Court. So the legal avenue is closed. But the investigative avenue is wide open. And that's where the tension lies. Investigators now have the green light. But they also know that every move they make will be scrutinized. Every document request will be analyzed. Every step will be framed as either justified or overreach, depending on who's telling the story. And Melania Trump's team knows this. They know that even if they lose every legal battle, they can still control the narrative. They can still make this painful for the investigators. They can still create enough doubt, enough noise, enough questions that the public never fully trusts the outcome. This is not a new playbook. We've seen it before, but it's effective, and it's being deployed right now. Here's what we know for certain. The Supreme Court has spoken. The appeal is dead. The subpoena stands. And Melania Trump is preparing her next move. What we don't know is what that move will accomplish. Will it delay the investigation? Will it undermine its credibility? Will it create a political backlash that makes the entire process too costly to pursue? Or will it simply be noise? Because there's another possibility here. The possibility that none of this matters. That the documents, once turned over, reveal nothing of consequence. That the investigation concludes quietly. That the entire legal drama was just sound and fury. But if that were true, why fight so hard? Why take this all the way to the Supreme Court? Why prepare a public relations counteroffensive? You don't do that unless there's something to protect. You don't burn through legal fees and political capital unless you believe the alternative is worse. And that's the calculation that legal experts are trying to understand right now. What is in those documents? What could they reveal? And why is Melania Trump willing to fight this battle on terms that are increasingly unfavorable? Let's talk about precedent for a moment, because this case doesn't exist in a vacuum. It exists in a legal environment where executive privilege has been tested, expanded, and contracted over decades. Richard Nixon tried to use it to shield the Watergate tapes. Bill Clinton tried to use it to protect conversations with advisors. Donald Trump tried to use it to block congressional subpoenas. And in almost every case, the courts have said the same thing. Executive privilege is real, but it's not absolute. It has limits. And those limits are defined not by the person claiming the privilege, but by the courts themselves. Melania Trump's legal team tried to stretch that privilege in a new direction. They tried to argue that it extended not just to the president, but to the president's spouse. That it covered not just official duties, but private conduct. That it applied not just during the term of office, but indefinitely. The courts rejected every part of that argument. And now the Supreme Court has refused to even revisit it. That's a message. A clear, unmistakable message. And the message is this: if you want to claim privilege, you need to meet a very high bar. you need to show that the information being sought is tied directly to official presidential duties. You need to show that disclosure would harm the functioning of the executive branch. And you need to show that there is no other way to obtain the information. Melania Trump's case met none of those standards. And so it failed. But here's the part that matters. The failure of this legal argument doesn't mean the fight is over. It just means the fight is changing shape. Because Melania Trump's next move, according to those close to the situation, is not to comply quietly and move on. It's to argue that compliance itself is a form of injustice, that the subpoena is illegitimate, that the entire process is tainted. And if that argument gains traction, if it finds an audience willing to believe it, then the investigation becomes not just a legal matter, but a political one. And political matters are messy, they're unpredictable, and they don't always resolve the way the law says they should. So what does this mean for the investigators? It means they need to be flawless. They need to be above reproach. They need to make sure that every step they take is legally sound, procedurally correct, and beyond any reasonable criticism. Because if they make a mistake, even a small one, it will be magnified. It will be used as evidence of bad faith. It will be wielded as proof that this was never about the law. And that's the game being played right now. It's a game of credibility, a game of perception, and a game that will be fought not just in courtrooms, but in living rooms, on social media, and in the minds of millions of people who are trying to figure out what to believe. Here's what we're watching for in the days ahead. First, will Melania Trump's legal team file any new motions? Not to appeal the Supreme Court decision, because that's impossible, but to challenge the subpoena on other grounds: bad faith, overbreadth, harassment. Second, will there be any public statement from Melania Trump herself? She has been largely silent throughout this process, but silence can only last so long. At some point, she may decide that her voice, her framing, her personal narrative is the most powerful tool she has. Third, what will the investigators do next? Will they move quickly to enforce the subpoena, or will they proceed cautiously, knowing that every move is being watched? And fourth, what will the documents reveal? Because ultimately, that's what this is about. Not the legal arguments, not the public relations, but the actual substance of what's being investigated. If those documents are damning, then all of this legal maneuvering will look like obstruction. If they're innocuous, then all of this will look like overreach. And if they're somewhere in between, then the interpretation will depend entirely on who's doing the interpreting. This is not a simple story. It's not a story with clear heroes and villains. It's a story about power, about accountability, and about what happens when those two forces collide. The Supreme Court just made a decision that says the law applies to everyone, even to people who lived in the White House, even to people who wielded influence at the highest levels of government. And Melania Trump's response to that decision will tell us a lot, not just about her, but about how far the boundaries of privilege and immunity can be pushed in this country, and what happens when those boundaries push back. This is a moment, a small moment in a much larger story, but it's a moment that matters because it's a test of whether our legal system can hold powerful people accountable, a test of whether proximity to power grants you protection or just scrutiny, and a test of whether the rules that apply to everyone else also apply to those who once lived at 1600 Pennsylvania Avenue. The answer to that test came 1 minute ago, and the Supreme Court said yes, the rules apply. Now we wait to see what Melania Trump does with that answer.